Appeal is now in session.
Good morning. We are here this morning for the argument in State v. Jouppi, file number A13147. Are the parties ready to proceed?
Yes, Your Honor.
Okay, Mr. John, you may proceed.
I'm the appellee, Your Honor.
Oh, sorry. Right, you're right. Mr. Soderstrom.
Good morning. May it please the court. My name is Donald Soderstrom. I represent the state of Alaska in this appeal. For hundreds of years, statutes in England and America have permitted or even required the forfeiture of vessels that were used to illegally transport goods without any excessiveness analysis. Like a modern airplane, those vessels were instrumentalities of an offense, that is, the means by which the offense was committed. That property was considered tainted and it was subject to forfeiture even if the owner was not the offender. Those forfeitures were not considered punitive, they were considered remedial. They were trying to remove property that was causing injury or remove property because it was hazardous in the hands of this particular owner. When an airplane is used to transport alcohol illegally, there are also public health or safety reasons to forfeit the plane. Historically, many forfeitures were in rem against the guilty property itself, but the Alaska Supreme Court long ago recognized that the analysis should not change depending on whether the state proceeds in rem or in personam. Either way, the same misconduct involving the same property is at issue. If the property belongs to someone other than the defendant, then the state has to proceed in rem against the property or separately charge that owner with an offense. But the legal standard should not change merely because the state kills two birds with one stone by seeking forfeiture in the criminal case rather than instituting a second case against the property itself, where the burden would shift to the owner to prove that it should not be forfeited. The US Supreme Court has never applied the gross disproportionality test to an instrumentality or found that the forfeiture of an instrumentality was unconstitutionally excessive. In Bajikagian, if that's how you pronounce it, the Supreme Court did not overrule hundreds of years of precedent and hundreds of years of forfeiture. The majority found that the unreported cash in that case was not an instrumentality. The majority did not believe that the cash was actually tainted by the failure to report. In all of in the previous cases involving ships and cars and distilleries, the property at issue was an instrumentality. It was the means by which the crime was committed.
Mr. Soderstrom, let me interrupt you for a moment. So here, forfeiture of cars or ships is discretionary, but airplanes are mandatory. Did you find anything in legislative history to explain that distinction?
No, I didn't find anything for that specific distinction, but when we're talking about forfeiture of whatever type of vehicle is actually used to transport the alcohol, it does make sense to look at what is the differences between transportation. That forfeiting an airplane is less likely to impact a person than forfeiting the family car or the skiff that people use day in and day out around the state. The forfeiture of an airplane is more likely to reach people like Mr. Jouppi, and he is who this provision is actually targeted for a pilot who is bringing alcohol illegally into communities that have banned alcohol. But no, there was no, I don't think there's any specific legislative history on why it's mandatory for airplanes, but why it's discretionary for other types of vehicles. But I think that is the most likely reason that it's different to order forfeiture of an airplane rather than the family car.
Okay.
And the Bajikagian majority specifically distinguished the unreported cash at issue in that case from an automobile that facilitates the transportation of goods. And the court in footnotes 8 and 9 of that decision said that a forfeiture that goes beyond the forfeiture of a car or a vehicle, that goes beyond an instrumentality, is ipso facto punitive and subject to excessive fines analysis. And in that portion of the opinion, the court relied on Justice Scalia's concurrence in Austin, which is where he wrote that an instrumentality, the value of an instrumentality is irrelevant to its forfeiture. That's where he said, for example, scales used to measure drugs, that was a drug case, are confiscable whether they're made of pure gold or base metal. And the historical limitation, I think, can be strictly construed that any modern forfeitures that go beyond that historical, I guess, exemption from excessiveness analysis for this type of instrumentality might not fall within this exemption. But I think the analysis, the analogy of an airplane used to illegally transport alcohol it's a close analogy to a ship that illegally transported goods 200 years ago. And the instrumentality analysis also avoids an obvious problem, which is allowing a criminal to keep his property if it's more expensive, but requiring him to give it up if it's less expensive. And people should not be able to make themselves forfeiture proof simply by using more expensive equipment when they commit crimes. There are other categories of property that also would not be subject to excessiveness analysis. For example, contraband, which a person has no right to keep or possess in the first place. Or, for example, restitution. If restitution is properly calibrated, then it is not punitive. It should be entirely remedial and would not be subject to excessiveness. Moving on to the gross disproportionality test. If the excessive fines clause applies to instrumentalities like the one in this case, that is the starting point, not the end point. A fine is unconstitutional only if it's grossly disproportionate to the gravity of the offense. The forfeiture of the airplane in this case is not disproportionate. It's not even unusual. It's a defendant's burden to show gross disproportionality, and the Alaska Constitution only forbids penalties that are inhuman, barbarous, completely arbitrary, or shocking to the sense of justice. That's the Alaska Supreme Court terminology from 40 years ago, considering cruel and unusual punishment. This court has upheld the forfeiture of airplanes, boats, and motor vehicles, even if their value was tens of thousands of dollars and several times the maximum fine for the offense. By analogy, punitive damages awards can be hundreds of thousands of dollars and many times the actual damages. Those types of awards show that forfeiting an instrumentality in a criminal case does not shock the sense of justice and is not grossly disproportionate. To get a sense of what might be grossly disproportionate, in Bajikagian, the court held that a forfeiture of a non-instrumentality, the cash in that case, of 71 times the maximum fine under the federal sentencing guidelines for a mere, what it called a reporting offense, was grossly disproportional. So 71 times in that case was grossly disproportional. In the Pennsylvania case that Mr. Jouppi relies on, that was theft of $200 from a casino, and a mandatory fine was 375 times the value of the actual theft in that case. That was a $75,000 mandatory fine for a small theft from a casino. And that was a regular fine. That was not a forfeiture of an instrumentality. Looking at this case, importation is a serious offense. Unlike many felonies, it carries a mandatory minimum sentence, including jail time and a fine, in addition to the mandatory forfeiture of an airplane if an airplane is used to commit the offense, or discretionary forfeiture of a car or a boat. At the time of the offense, Mr. Jouppi faced a $10,000 maximum fine, but this court in the past has considered legislative changes. Today, he would face a $25,000 maximum fine. If he were a recidivist, if this were a felony based on his recidivism, he would face $50,000. One more case of beer, and this would be a felony, and he would face a $50,000 maximum fine based on the quantity of alcohol.
Mr. Soderstrom, I have a question actually about the conviction here. So do we know, I understand that the state's theory of prosecution was that Mr. Jouppi was willfully blind to all of the alcohol that the woman possessed. But couldn't the jury have convicted him all the same, even if they only found that he was aware of the six-pack that was easily visible?
Well, willful blindness was an issue, but there was also evidence that the state presented that Mr. Jouppi was actually looking through the boxes, moving things around, and the testimony of one trooper was that he would have had to be physically blind not to see this alcohol. So, while
no, I understand that the state made those arguments, but my question is, do we know that the jury necessarily accepted those arguments? In your brief, you assert that the jury clearly rejected this defense that he didn't know about that other alcohol, or that he wasn't willfully blind about the other alcohol, and can't what we're dealing with in terms of the actual elements that the jury has to find is just any amount of alcohol. So it seems to me that the jury verdict standing alone doesn't answer the question of how much alcohol he was aware of or willfully blind to.
Okay, well, Mr. Jouppi's testimony was that he was unaware of any alcohol. The jury, if it proceeded on a willful blindness theory, willful blindness for 40 years since the 1978 code revision has counted as knowledge, as knowingly under the AS 1181-900A. So willful blindness, whether it extended only to one six-pack that was in plain view or to the entire 9 gallons, there's no way to say that he was only willfully blind to some of the alcohol and not to all of it. If he was willfully blind, then he knew of a substantial probability that there was alcohol on the plane, and if he chose not to check, then that's not a legal defense. That's not even a mitigating factor. If he was willfully blind to any of it, then he was willfully blind to all of it.
No, I understand that. I'm just in terms of, there are, as you probably know, certainly Justice Gorsuch and other people are concerned about Seventh Amendment issues related to restitution. And just from a constitutional perspective, just wondering, is the judge allowed to say or to find, I find that he was willfully blind as to all the alcohol, or are we committed to the kind of narrowest finding that would support the conviction, which is he was willfully blind as to at least the six-pack?
Well, the narrowest would be that he was willfully blind to at least the six-pack, which is a misdemeanor, and which the legislature has said forfeiture of an airplane is still mandatory for any amount of alcohol if you use a plane.
Right, but wouldn't this go to the Bagagian factors of the seriousness of the offense? I mean, you made in your brief, you make arguments that this is almost felony level, and that's how we should view it. And I'm just wondering, is that how we should view it? That we have established for purposes of the forfeiture analysis that this is almost felony level?
Well, at this point, I should point out that on page 320 of the record, the sentencing judge said that the court would assume without deciding that Mr. Jouppi's culpability extended to all of the beer.
Right.
So that was the basis of the trial court's decision.
Right. And the question would be, can the trial court do that under the Seventh Amendment?
Right.
Can the
I agree
trial
with you.
court assume that it extended to all rather than just the six-pack, which would be the narrowest grounds? That well, whether the jury, I don't see a way to distinguish.
It seemed to me that your answer partly, let me see if you kind of answered my question without realizing you'd answered my question, which it sounds to me like what you said was that nobody argued that theory to the jury, that's why it's not a believable theory. Is that correct? That nobody argued he's only aware of the six-pack, that basically was an all or nothing, he's willfully blind as to everything, or he was unaware of everything?
So the prosecutor didn't say he only knew about the six-pack. And Mr. Jouppi denied any knowledge of any of the alcohol. So the parties at trial, yes, it was an all or nothing. It was not. I don't think that the prosecutor argued that he's responsible for everything. But our fallback position is that he at least saw this six-pack,
okay,
and knew about that. And his position was that. At trial was that he didn't know of any of it. He had no actual knowledge of any of it, which is contrary to his position now in the trial court on remand and now, which is that, well, at most he was only willfully blind to one six-pack.
Mr. Soderstrom, was there evidence in the record about what the unrelated investigation was that that the search warrant related to, or was there any proof of other? I know there's sort of suggestion that maybe Mr. Jouppi had transported alcohol in the past, but was there any definitive proof on that? And did the judge make any findings about other uncharged conduct?
I don't think that there was any litigation, at least in the record on appeal, about what the basis for the search warrant was, or any other criminal history from Mr. Jouppi. We do know that there was a search warrant, so there was probable cause to stop him on this particular occasion, but I don't think that we can really speculate beyond what the underlying facts were based on the record on appeal. On the issue of Mr. Jouppi's livelihood. So Mr. Jouppi raised this argument for the first time in his appeal based on language in Timms versus Indiana, but the Supreme Court has never held that a forfeiture cannot deprive a defendant of his livelihood. The court specifically declined to answer that question in Bajikagian. In Timms, the court specifically said that not each and every application of a right is deeply rooted. And of course, it was the court was citing the Magna Carta, which in Browning Ferris, the court warned against placing too much emphasis on 13th century English practice. The historical evils that the Supreme Court was looking at in Timms were the equivalent of $1 million fines for speaking out against the crown or against political enemies, or laws that essentially tried to reenact slavery post-Civil War. And if a defendant could not pay those fines, then he could be imprisoned. So those fines were more like forfeiture of estate, which we don't have, and which forfeiture of an instrumentality is not like taking everything that a person owns. Most courts consider the question have found that inquiring into a defendant's livelihood is unnecessary. In other circumstances, such as restitution, Alaska courts are barred from considering the ability to pay when setting the amount. And of course, with a forfeiture of an instrumentality, the person is able to pay the fine. And the whole idea of a person's livelihood has changed over the years. People work multiple jobs throughout their lives. They're more mobile, they retire, they have retirement accounts or pensions, Social Security. We have bankruptcy laws that determine what property people are allowed to keep. In Alaska's Exemptions Act, AS 09.38, the legislature specified that a person who is civilly liable can keep a few $1,000s worth of tools of the trade, not a $95,000 asset that was used to commit a crime. As a factual matter, Mr. Jouppi has not shown that forfeiture would deprive him of his livelihood. He was the only pilot for Kenneth, and he had 2 planes, and he flew his passenger out that same day of the incident. He's still free to pursue a livelihood as a pilot or as a licensed mechanic.
Well, Mr. Soderstrom, I mean, as you pointed out, the sentencing judge didn't rely on this theory.
Mm-hmm.
In fact, as far as I can tell, in the written decision of the trial court, there's no mention of this, means of livelihood theory. So there was no finding made. Wouldn't that be a finding of fact, whether the forfeiture of the airplane would effectively deprive Mr. Jouppi of his livelihood? Wouldn't it be improper for this court to decide that issue in the first instance?
Yes, it would. To the extent that this question involves, well, it's a legal question whether we should consider this livelihood theory at all, to what extent that is the law. The underlying factual questions, such as what effect this would have on him, those are factual questions. And because Mr. Jouppi never raised this theory in the trial court, we don't have a record. The record that we do have suggests that this does not deprive him of his livelihood. Also in the Indiana Supreme Court on remand in Timms versus Indiana suggested that if a property owner does not put in that evidence, then he has failed to make his case on the livelihood theory. Some other ways, the trial judge in this case underestimated the gravity of
Mr.
importation.
Soderstrom, I want to make sure that you know that you're going into your rebuttal time.
I'm aware, yes.
Okay,
Thank you.
go ahead.
I left myself some extra. The judge underestimated the gravity of importation in general, as well as I think the seriousness of this specific case, which we've already talked about, whether it's 1 6-pack or the whole 9 gallons. The judge repeatedly said that Mr. Jouppi attempted to import alcohol, but this offense, of course, includes importation in the completed. There's no distinction between the completed offense and the attempt. Mr. Jouppi would have been successful if the troopers had not stopped him, so he's no less culpable simply because the troopers stopped him before they took off. And the judge said that he could imagine more egregious violations, but that's not the right question. The legislature did not give judges discretion to forfeit planes only in egregious cases. They said that whether forfeiture is mandatory or discretionary depends on the method of importation. And finally, the constitutionality of a forfeiture is a question of law, meaning that given the same facts, there's no room for discretion among individual judges. So then the question is, what is the upper limit on the legislature's authority, and what test should the legislature or should trial judges use? Essentially, what's the equation? If $95,000 is unconstitutional, what is the point? At what point did that become unconstitutional? Would an airplane worth $80,000 be constitutional, or $50,000? For other offenses, because the same equation should generally apply. In a DUI case, how bad does the driving have to be, or how high does the alcohol content have to be before a car worth X dollars can be forfeited? So if the mandatory forfeiture is excessive, then the court should determine the point at which it became excessive and order that much of the property forfeited. Otherwise, the legislative intent would be undermined, and this would mean that a person who committed a crime with a $50,000 airplane, for example, might lose it, whereas a person who commits the same crime with a $95,000 airplane apparently gets to keep it. So I would like to reserve the remainder of my time for rebuttal.
Thank you, Mr. Sostrom. Mr. John?
Yes, Your Honor, may it please the court. I'm Robert John on behalf of the appellee, Kenneth Jouppi. Mr. Jouppi had reached the age of 69 without having anything more on his record than a traffic ticket. Then one day, a passenger of his decides to bring some beer to the village for her husband, and bringing beer in and of itself is not a crime. It just, the problem in this case was it was a dry village, and that was the issue. She was bringing some beer, going there to celebrate her birthday. She herself didn't drink. Mr. Jouppi had piloted her before, never noticed her to have any alcohol on her breath. So we have the situation there, and there was quite a disputed trial about what the testimony was, about what Mr. Jouppi saw and didn't see. He said he didn't see any of it. The state's case focused in the end ultimately on saying he certainly saw the alcohol that was in the grocery bag that was loose in the plane, the 6-pack of beer. He said he didn't see that either, but we have here the jury never made any kind of finding as to how much alcohol, and our position is that for the purposes of this proceeding, if we want to go beyond the 6-pack, the state really needed to get a finding from the jury as to how much alcohol that had been imported had been brought onto the airplane.
Could the sentencing court, Mr. John, could the sentencing court consider Mr. Jouppi's testimony that he made a practice of not looking too closely into what his passengers were carrying? Because he, as he put it, he said if he did do that kind of search or check, he'd lose business.
I don't think that the sentencing court can really rely on that. There was a specific jury instruction that was entirely legal for him to do that, and it's probably the practice of most carriers. Like,
no, I'm not saying that. I'm not saying the jury should have considered it. I'm just saying couldn't the judge validly consider that when assessing whether particular penalty was excessive or commensurate?
I don't think so, Your Honor, because it's part of his jury trial right, for one, and secondarily, when he's engaging in a normal, acceptable business practice, which, he's trying to protect the privacy of his passengers. He doesn't want to do unnecessary searches that they're going to find offensive, and they may fly with him that time, but that would be the last time they'd fly with him. So I don't see there's any reason that should be assumed against him, that he didn't check for it. There's no legal obligation for him to check for it. So I don't think the judge should be allowed to consider him not checking for it as anything to be held against him in determining how much alcohol is at issue for sentencing purposes.
Well, what about the case law we have that suggests a sentencing judge can make findings by a preponderance of the evidence, even when a jury's rejected or acquitted someone for that conduct beyond a reasonable doubt?
Well, in this case, when he has been convicted, Your Honor, there's a question there as the right to jury trial as to the sentence. It's a punitive component right here in the forfeiture. So the case law indicates, from my perspective, at least, in Mr. Jouppi's, that if the state wants to enhance or increase its sentence with this forfeiture, there has to be factual findings by a jury to justify the forfeiture. So, and as I read Judge Hammers, is in the end, he assumed for the purposes of argument that all the alcohol was involved, but in his own mind, his finding was really that, from the perspective that it was only really the 6-pack, because that was what was actively litigated. That was what the state put pictures on. They had showed the jury the bag from Fred Meyer and whether one could see through the bag or not. And that's what really was at issue there, was the 6-pack. And, in any event, even if you take the worst case scenario, this is still a misdemeanor. And the state talks about some federal cases, and one of the more interesting ones was the Ninth Circuit case. It cited in its reply brief I believe the $132,245 in currency case. In that case, the court, in doing a Bakajian analysis, said, well, we look at the ultimate penalties, but we focus more closely on the sentencing guidelines, which is, and the court may or may not be familiar with the sentencing guidelines, but it's a matrix basically, where on the horizontal plane you're looking at criminal history. Mr. Jouppi had none, and on the other plane you're looking at the severity of the offense, and you go down there and try and figure out what the sentence should be. We don't specifically have that, but we allow our judges the discretion, and Magistrate Judge Hammers exercise that discretion in this case, and he looked at the totality of the circumstances, and he concluded that nothing more than the mandatory minimums were appropriate in this case, including a $1,500 fine, and that's compared to $95,000 in forfeiting the airplane. So I think we have to look at Judge Hammer's conclusions there. Even though the ultimate issue of forfeiture is a legal question, the underlying facts and the exercise of the trial court's discretion guide that decision. And in this case, Judge Hammers clearly found this was not a worst case scenario. It's more of a least case scenario, whether you look at it as merely a six-pack or some larger amount. You also have to look at the fact that here's Mr. Jouppi, having flown for decades, never had an issue with this before, never had any criminal record whatsoever other than traffic violations. So when you look at it from that perspective, this is a very severe fine. And the cases that are relied upon by the Alaska cases, at least, seem to involve situations where there are people engaging in heinous game violations, people engaging in fact, repeated instances of heinous game violations, and some of them have had forfeitures previously, and they're back at it again. And you have cases of DUI, and under the DUI laws, we don't forfeit people's vehicles for a first-time offense. It usually takes a third offense or a felony for there to be any forfeiture. And when you look at it, a DUI is something that we can basically say it's malum in se. It's dangerous for the public, for anyone to engage in a DUI. This conduct here, well, it's certainly malum prohibitum. It's been prohibited by law, by the fact that this is a dry community, but it's not necessarily anything that's dangerous in the first place, at least under the circumstances of this case, where the evidence indicates it was personal use, fear that was being brought to this village.
Well, Mr. John, on that issue, I would argue that the history of forfeiture shows that the first Congress and then the Alaska legislature viewed this as an appropriate punishment in terms of deterrence. One of the earliest forfeiture statute I could find that applies to Alaska was enacted by Congress in September of 1868, which is like half a year after possession was transferred to the United States, calling for the forfeiture of vessels used to bring alcohol to the District of Alaska, as it was then. And ever since that time, basically for 150 years, the penalty for bootlegging has included forfeiture of the conveyance of the vessel, the airplane. So historically speaking, it's not like DUI. I mean, you could argue that DUI is a more serious crime, but the history of this legislation shows that ever since Alaska was first formed or purchased, that the government has considered forfeiture of these vessels to be an appropriate penalty for bootlegging.
Your Honor, that's the catchiness of that word. Bootlegging connotes some type of activity where one is engaged in a for-profit transportation of an illegal good. And that's not what Mr. Jouppi was doing. That's not even what his passenger was doing here. Mr. Jouppi had a fare paid by this passenger that was going to be the same fare regardless. The passenger chose in the end to bring some alcohol along with her, but that didn't affect the fare. Mr. Jouppi didn't make any bootlegging type profit for this. And as I read those cases, that the way the U.S. Supreme Court has discussed them, in those cases, the forfeiture was viewed as non-punitive. But there is no question in this case that the forfeiture is punitive because it's a criminal forfeiture. And as a criminal forfeiture, Bakajian says it doesn't matter if it's an instrumentality or not. And even if
I'm not sure I read Bajikajian that way. I mean, it looks to me like the court in Bajikajian just says we don't have to worry about that, about this traditional exemption for instrumentalities, because it's so clear in Bajikajian's case that the currency was not the instrumentality of any wrongdoing.
But they specifically say in the footnote that that's irrelevant in any event because this is clearly a punitive sanction. And as the jurisprudence has developed, and I believe Tim supports this as well, is that whether it's deemed as a punitive criminal forfeiture or an in rem civil forfeiture, under the present law, the proportionality test is employed. So we still have to look at the underlying facts there. The two federal airplane cases that are cited by the state, the Wallace case and the D. Gregory cases, appears to be illegal instrumentality there. And in those cases, they still undertake the proportionality analysis. So it's just not the law that all you have to ask is it an instrumentality? And if it's an instrumentality, no further questions. That's just the start of the analysis.
Well, let me ask you about Mr. Soderstrom's suggestion that if we agree with the trial court that the forfeiture is excessive, shouldn't we then reduce it and direct the trial court to enter a monetary judgment for some lesser amount?
Your Honor, I don't believe that's appropriate for several reasons. One, the state never advocated for it below. Secondarily, the statute doesn't allow for it. The legislature has basically set forth an all or nothing statute with no discretion in any court. And so that's a problem with the statute. If the legislature wants to go back and establish another scheme that would allow for some graduated type forfeitures, that would perhaps be permissible, and that could be litigated at a later point. But the thing is, there is no authority for that. And right now, the case law doesn't, I've not seen any case law that allows for this. It's, you look at what's trying to be forfeited, and if it's something that's significant, and it's excessive, that you can't forfeit that. Now, that's the scheme we have. It's an all or nothing. It's you forfeit this plane or you don't forfeit anything at all. And if the court were to do that, I believe we need to consider, what Mr. Jouppi has already forfeited. He forfeited 2 years of the use of his plane. And on top of that, and this is undisputed testimony, the state didn't maintain the plane. A plane is something that likes to be used and maintained. So in order for Mr. Jouppi to restore the plane to the condition it was in when the state first took it, he put about $35,000 of expenditure and time into that. So those are significant forfeitures in and of itself that certainly should be taken into account in the calculus. Mr. Jouppi believes the court doesn't have to reach the livelihood question in order to affirm Judge Hammers, but if the court's going to send it back, that should certainly be at issue as well. The state says, oh, he had another airplane. Well, yeah, that he had another airplane, but airplanes are used for different purposes. This was his breadwinner, his lead horse there that did the work. You have another plane with floats on it, but that has limited use. If you look at Mr. Jouppi is basically making a living by chauffeuring people through the air around Alaska, it'd be like saying, okay, we're going to take your limo, but it's okay, you still got a Yugo. It just doesn't, it's depriving him of his livelihood to take this plane from him. And whatever the law may have been prior to Tim's, and it's still a little uncertain, Tim's makes clear that the analysis in the Levesque case from the Second Circuit, that the question about deprivation of livelihood is either part of the inquiry or it's an entirely separate inquiry that in and of itself is sufficient to declare a forfeiture to be excessive.
Well, on the question of how Mr. Jouppi makes his livelihood, I mean, my understanding of the record is that Mr. Jouppi makes his livelihood by selling his services as a pilot to Ken Air and also leasing a plane to Ken Air so that he's got something to fly while he's selling his services as a pilot. I mean, even if the airplane is forfeited, wouldn't Mr. Jouppi continue to serve as a pilot for Ken Air and just lease another plane?
Well, he owns that plane and he has another plane. And those were the two planes he had, the float plane and his breadwinner plane. And so he'd have to go out and get another plane if he was going to lease it to Ken Air.
No, but why couldn't Ken Air just lease somebody else's plane? Mr. Jouppi could continue to fly for Ken Air, make his salary.
Well, but and Mr. Jouppi owns Ken Air, so it's really going to result in the same situation where there's going to have to be an expenditure there that would not have to be undertaken otherwise. If he has
Well,
to
that
go
leads to my next question. It seems like the relationship between Mr. Jouppi and Ken Air is so close that we should be looking at the $500,000 minimum or maximum fine for this offense that a business organization faces, and not the $10,000 or even $25,000 now that Mr. Jouppi as an individual would face. I mean, Mr. Jouppi testified that he doesn't even have a separate bank account for Ken Air. It's all coming out of the same account. And you say, well, it's he's leasing his plane to Ken Air, he's selling his services to Ken Air, but I mean, Ken Air is him, right?
Well, it is an LLC, Your Honor, and the law is set up so there's various purposes for an LLC as a business entity. But Mr. Jouppi is the one who owned the plane. That is undisputed. So the question is, for forfeiting the plane, is who owned the airplane. There may be other issues related to Ken Air, but the state never really pursued these before Judge Hammers, and they certainly didn't bring them up on appeal, and they didn't even make Ken Air a part of the appeal. He made the finding that Ken Air is not the owner of the plane, and the state didn't contest that finding. So the court, certainly for the purposes of reversing, shouldn't be undertaking some kind of analysis like that when the state.
But you as lawyer for Ken Air opposed the forfeiture of the plane. You litigated and filed motions opposing the forfeiture of the plane. What was your basis for engaging in that litigation? You must have had standing, right?
Well, because Ken Air and Ken Jouppi were both convicted. So the question at the time was who owned the airplane. So Ken Air took the position that it did not own the airplane, and I at that point was advocating for Ken Air because Mr. Travoso, before he took the bench, was advocating for Ken Jouppi. That was argued. We went through the hearing. Ken Air was ruled by Judge Hammers not to be the case. The state did not appeal that to this court, so Ken Air dropped out. So trying to go back and argue about Ken Air at this time when the state did not file an appeal against Ken Air, that's a done deal, Your Honor. That should not be re-explored on appeal here when the state didn't pursue that issue by bringing Ken Air in. So right now, Mr. Traverso took the bench. I took over because of my familiarity for Ken Jouppi, and that's who's in front of the court right now. He was the owner of the airplane, and he has his conviction for that. The Ken Air conviction is all done. That's not being litigated by anyone anymore. So this is not the appropriate proceeding in which this issue should be brought up, certainly not as a basis for reversing Judge Hammers. The fact that the legislature may have made the law a little more severe right now as to the maximum penalty doesn't affect the issue as to what the mandatory minimum is. It's still the same. It's still like a first-time DUI, $1,500 fine. Mandatory minimum, that's what Judge Hammers imposed. when you talk about levels of egregiousness, it's really hard to imagine a less egregious case in this case, where somebody's bringing beer onto a plane. We have our communities that are dry, and that's certainly a valid, legitimate, even important concern. But in the scope of the behavior that you're looking at of what can all happen, it's like, well, someone can bring beverages into a community that are just for personal use. Someone can bring a small amount in, someone can bring a little amount in, or someone could bring in a whole pallet of beer, wine, and liquor. And, that might be the type of person that we're looking at for having this forfeiture against. But when you look at the circumstances here, it's excessive under the maximum fine, it's excessive under the actual fine, and the type of situation where a forfeiture would be justified is the type of situation where it's justified in other cases, DUIs and multiple convictions, multiple game violations where there's heinous conduct right there. Mr. Jouppi, someone with no prior record, should not be losing his livelihood and not be losing a plane worth $95,000. It's just excessive there, Your Honor.
I'm not really familiar with the aviation industry. Are there a lot of planes that are worth less than $10,000?
These days, probably not, and they're probably not. But if they are, they might be smaller planes engaged in other activities. But Mr. Jouppi's plane was worth $95,000, and that's why you need to consider the exact circumstance of the case, that this is basically some beer for her husband's birthday that was brought by someone. There was no indication in the record that Mr. Jouppi had a pattern of this. There's no indication that he knew ahead of time what was up. And this is what he was talking about in his testimony. This all happened. She shows up. He's running behind. They're loading the plane quickly. He's getting ready to take off. And then all of a sudden the troopers show up there at the last minute before he takes off. This was not a pre-planned thing in any event. And certainly Miss Nikolai would not probably have told him if it was pre-planned, because then he'd say, no, you can't do that. So she's not going to tell him about it. And, the question is, what did he see? Well, his right to a jury trial, which attaches to any punitive component of the case, is that all we can say is that there was a six-pack in a grocery bag. He should have seen through the bag, or maybe seen through the top and seen that there was beer in here. That has to be presumed to be the jury's finding. All these other allegations don't really have any weight. And even if they did, it's still a misdemeanor. Judge Hammers, who was there, who heard all the testimony, exercised his discretion in setting the sentence. And that's part of the real benchmark here, is not what the legislature said the maximum is. Far more important is what the trial court determined the appropriate sentence was.
Well, I have one final question. You've said several times that the right to jury trial attaches to any punitive aspect of the case. My understanding of Blakely is that once the jury finds him guilty of an offense for which the penalty by statute includes forfeiture, that's it. I mean, you've gotten your jury trial, and the question of whether to impose the forfeiture sometimes is within the judge's discretion, sometimes is required by statute, but it's not a punitive aspect of the case to which right of jury trial attaches.
I believe it is, Your Honor, to the extent the forfeiture is necessarily subject to the excessive fines clause. That means that the forfeiture has to be weighed in view of the facts as determined by a jury. So the legislature can say this, but it was really the state's burden, because a forfeiture, and that's the problem with the statute, and the state went along with the statute, is that when we're going to have things subjected to an excessive fines analysis, the court really needs to, or the state, if it wants to have something forfeited, have a jury make a finding about the person brought in X amount of X and Y amount of Y, and and have that be found by a jury, so we don't have a situation, and this was just the problem with Blakely, is you'd get a jury finding and then they'd get hammered on appeal on the sentencing phase with all kinds of additional evidence or things that were found only by a judge. And
Well,
you know,
but
we have
that's, those are cases where the judge made findings that increased the authorized sentence beyond what the jury findings would have authorized. But here, that's not the case.
Well-
The jury's findings were sufficient legal basis, at least without consideration of your constitutional claim, were sufficient legal basis to impose the forfeiture.
under the statute, but if the statute is going to be then analyzed in view of the Constitution, I believe the constitutional right to have a fine that's not excessive as it attaches to the statute under which he's charged and convicted, and the right to jury trial necessarily requires the jury to make findings that, so he's allowed to have the jury determine his culpability, not just the sentencing judge determine it all after the fact, because this is the real penalty in this case, Your Honor. This case could have been pled out. This case had really, was not much of a case at all when we're just looking at, it's a $1,500 fine, 3 days in jail. Mr. Jouppi might have pled out whether he was guilty or innocent because it's a lot less expensive to just plead out than go to a jury trial. But this case from the beginning is the state wanted Mr. Jouppi's plane, and they still want Mr. Jouppi's plane. But if they want it, they needed to have findings by a jury that would justify it, and they just simply aren't. And I submit on Mr. Jouppi's behalf that even if you look at the worst case scenario, this is still a first time misdemeanor, and that's what we have to start from. And forfeiting a plane under these circumstances, a $95,000 plane, when Mr. Jouppi had the loss of use of it for 2 years and had to put $35,000 into bringing it back to its value, is grossly excessive. I'd just like to go back to the livelihood question, Your Honor, and address that briefly here. There was testimony about that before Judge Hammers. He didn't make findings. It's our position that the court does not need to reach that issue to affirm the decision of Judge Hammers. But the uncontroverted evidence in this case is that it's a livelihood problem. But at a minimum, if the court is going to send it back and not affirm Judge Hammers, we should be allowed to go back and explore this issue further on remand, though we believe it's not necessary. In short, to reiterate, this is a first-time misdemeanor, $1,500 fine, 3 days in jail, equivalent to a first-time DUI where a vehicle is never forfeited. The statutes at issue don't forfeit personal vehicles and boats. They do forfeit airplanes, but that's the problem is, you can look at it from Mr. Sotoson's perspective. It's like, oh, they may have those for family use, but at the same time, it's just important as an airplane is probably a person's livelihood. And that's part of what the state took in this case was Mr. Jouppi's livelihood. If the court doesn't have any further questions, I'll conclude at this time. Thank you.
Mr. Soderstrom?
A few responses to that. The court should not allow another remand for Mr. Jouppi to raise another argument that he did not raise the first time around or even the second time around, which is the livelihood issue. Bringing beer to the village of Beaver was a crime. It was bootlegging, or another term would be smuggling. Mr. Jouppi was doing this for a business. He and Kenneth were one and the same. They had the same checking account. He owned the planes, even though the company apparently paid for some of the maintenance. They were one and the same. And so under these circumstances, looking at the $500,000 maximum fine that the business would face, is appropriate, even if this had been just a person, a pilot who had a plane and his hobby was flying. If he flew himself and some beer out, then it might not be appropriate to look at the maximum fine for business. The state had to prove knowingly either actual knowledge or willful blindness. So this is not an innocent owner case. If the jury had found that he did not have that substantial that knowledge of a substantial probability that beer was on the plane, then the jury could not have convicted him. Looking at the fine that was the sentence that was actually imposed by Judge Hammers would be a problem, because the forfeiture, the constitutionality of a forfeiture should not depend on being sentenced by this judge or that judge, that Mr. Jouppi appeared before Judge Hammers rather than the judge next door. The legislature has determined that in airplane cases, airplane forfeiture cases, airplane importation cases, forfeiture of the airplane is the primary consequence to that action. The legislature should not have to increase the penalties across the board, increase the maximum fines, or increase the jail time just to achieve its goal in this scenario. As Justice
Mr. Stonestrom, forgive me, but to go back to your last assertion about whether the forfeiture should either be constitutional or unconstitutional is not really a question for a particular trial judge to determine under the facts of the case. I mean, it seems like Badgikagian says something very close to that. I mean, the facts of the case apparently were undisputed by the time they got to the United States Supreme Court, but somebody had to make those findings. And then the Supreme Court said under these facts, the forfeiture is unconstitutional. So, I mean, to that extent, isn't the sentencing judge or the trial judge necessarily an indispensable component of this process?
For the actual factual findings regarding a person's what happened, their culpability, but how a particular judge exercises their discretion within the statutes or within the federal sentencing guidelines, that should not be, if it's a factor at all, it should be a very minimal factor determining whether the forfeiture is constitutional. For the same property, the same offense, the same underlying conduct, just because one judge exercises their discretion in one manner and another would exercise it in a different manner, that should not be the distinction between something being constitutional and unconstitutional. But for actual factual findings rather than exercises of discretion, then yes, what the sentencing judge says is entitled to deference on that, but not the ultimate question whether it's constitutional. The state did not include Kenneth as a party on this appeal because Kenneth did not own the plane. After that finding, Kenneth has no interest in this case, and apparently it's also been disbanded. A special verdict would have answered the earlier questions regarding whether this was a 6-pack or 9 gallons. If the jury had made findings on that, then the judge, I don't think, would be able to make a different finding. But the verdict alone does require forfeiture as a matter of law, so there's no Blakely type issue here. That's all I have. Thank you.
Thank you, counsel. We will take this matter under advisement and we stand adjourned.